Okay, good question. I hear that bringing one's attorney to an ARD, which is an IEP meeting, some states call them ARDs, so I'm assuming you're in Texas, because that's like the main place that calls it an ARD. Okay, but I'm going to call it an IEP meeting. Is strongly discouraged because it creates an adversarial relationship. Same thing with recording the ARD. What's your take on this? And then, you provided the, necessary, attorney possesses knowledge. Yeah, it's discouraged for a reason, all right? Number one is that then it puts the district in a position to where they need to have their attorney there. And it does create a different dynamic because of the fact that, you have professional hats there who are typically triggered when there's no consensus on the team. All right, so attorneys typically get involved when there's a dispute or when there's no consensus on the IEP team. So we're sort of post-ARD, post-IEP. And so yes, it does. Now, do I think that my involvement would be beneficial? Of course I think it's beneficial in these meetings, but I can't control how other people perceive my presence. And that's really what you're doing. I mean, you want to make sure that the perceptions and what your goals are and what you're trying to accomplish are in line with the purpose of the IDEA, and that is to work collaboratively with your school system to reach a consensus on how to provide your child with a free and appropriate public education. And that would include training for staff, supports for your child, accommodations needed for testing, accommodations needed for navigating their environment inside the school. So the idea and the theory behind the IEP team or the ARD is that can be done collaboratively with the parent to reach a consensus, which is the goal. It's not majority votes. You get a vote and the school gets a vote. And that's consensus. And an attorney just brings a different dynamic. So yes, I do sort of discourage. And it's something that very rarely will I, and it depends on a case-by-case basis of why my presence might be beneficial outside of a due process or a mediation situation. Because I will attend an IEP meeting if I file due process or if I've already alerted the school system that I'm representing this client. But if it's just a regular IEP meeting because a parent wants extra support or backup, no. I won't go. What I will frequently do is I'll tell parents to have me on backup, text me during the meeting or step out, ask for a break and step out and call me. If you have any questions. Not that parents do that, but what it does is it does instill a little bit of confidence in the parent that they're not in there alone and that they do have somebody backing them up in a very complex process where there's a lot of educational language and acronyms thrown around that the parents don't necessarily understand. And that's why I think recording is so critical for parents. Because while you can't take shorthand notes if you're by yourself. And yes, there may be a school personnel taking meeting minutes, but that's the meeting minutes from their perspective, not necessarily from a parent perspective or how the parent understands it. And so, yes, this is sort of a a one-sided, and it doesn't meet, in my viewpoint, the goal of satisfying the law with regards to the parental rights to full parental participation is having a one perspective meeting note being taken. So I do believe that a parent should be able to record their ARD meeting or their IEP meeting. So in that regard, I don't care what schools say. I do believe a parent has a right, but at the same time, check your state laws with regards to one party recording. unless you want to let the school system know that you are intending to record. And as long as you provide them notice, most schools don't have an issue with it. Some do, which, and the excuses they provide parents, are it might sound good, but they can't point to any specific law that says that they can't. I mean, the federal law doesn't say you can or you can't. It's silent on the issue. And so if you go to OSEP guidance on the subject, they don't necessarily discourage it, and they don't necessarily, and they will say that, maybe it's not a good idea, but it's left up to the local school. But then when they say it's left up to the school, it also provides a huge caution, big flashing red lights, that if the parent requires the recording in order to fulfill the legal mandate for full parental participation, then they need to have the meeting recorded. Now, what is full parental participation? Once again, because these meetings are complex and we're using acronyms, and most of these meetings are within a specified time frame, and let's say a parent is by themselves, then the parent needs to be able to go back and listen to that meeting again in order to fully understand what happened. School people do these things all the time. I mean, it's just second nature. You've been in 1,000 IEP meetings. Parents have not. And so this is a complex situation, so it should be respected, and they should be able to record. Now, do I think parents should slap their recordings on the internet and on social media? Absolutely not. I don't think that that's conducive. I don't think that's positive, and I don't think they should do that. But do I think that they should have them for their own personal benefit in order to maximize their ability to be the best advocate for their child? Absolutely, I do. Now, back to the attorney thing. What I do recommend is that you find yourself a good advocate, and one that's been trained properly, that understands the differences between substantive aspects of the IEP as opposed to procedural. Because I have far too many advocates that are bulldogs on the procedure side, and they're just absolutely hammering schools on the procedural mistakes. And I don't, because this is important, but not if it hasn't damaged the substance of the child's program. The child's still making progress, and there's been mistakes over here, then the court's not going to care about the mistakes over here. If the child's making progress and on their substance of the program, the goals, the services, those kind of things. If that's moving forward. Now, are there times when there's a lot of mistakes in the procedural side that end up screwing up the substance of the program? Absolutely. But, I'm a trained attorney to sit there and be able to do that analysis of which when that happens. And some advocates just don't have that training. And then, some have a susceptibility to, sort of being one-trick ponies in this area, to where they're hyper-focused on certain things. And you want one that's a cool player, coming in there and making it about the child and being child-focused and solution-oriented, and being very, very mindful to maintain a positive tone on the IEP team, even if the school is being adversarial, and even if the school is being aggressive. There are just absolute ways and strategies to be effective human communicators. And keeping things child-focused is so incredibly important. So finding an advocate like that, that's what I would do. And at that point, it's not an attorney, but it's somebody that has your back, and it's somebody that can help you navigate the process effectively. And if your advocate sort of runs into obstacles and reaches a point where they can't, then they should have an attorney to pass that on to in order to take it the rest of the way. Okay? But I find advocates very beneficial to give parents backup at a low and affordable rate to be able to do that. Some, that is. But like I said, they're not all created equal, and neither are attorneys. So you got to do your homework to find the right one. And I mean, one of the things that we're thinking about doing is training parents that also want to work as advocates, and sort of having the Galini group stamp. But I tell you what, that process would be rigorous because, you know, the law is one aspect of it, but so much of it is more understanding the strategies and understanding how to navigate this process in a positive way. You know, and that's what we're trying to work out is an actual coursework that would be teachable and something replicable. And hopefully we're real close to finishing that. But you know, otherwise it would be a waste for us to just train people in the law, because the law is this much of advocacy. When understanding how to navigate the process effectively in a positive manner in order to accomplish the goal for the client is this much of it. And that not everybody has abilities in those areas. So I hope I answered your question. I think I did.